everybody. Good morning. Happy, what day is it of the week? Tuesday? Oh, I don't know. Ever since I quit my law job, I never know what day of the week it is. So, good morning. I am in pretty good spirits today. As y'all might have known, I was sick a couple days ago, was not feeling well. The powers that be were attacking me. I do not know. Thank you, Whitney. So today we are going to be starting a brand new series, and I don't know how long this series is going to last. I do not know where the twists and turns of this case are going to take us, just like I did not know whenever I started covering Britney's case where we would end up. I do want to just cover a couple things very quickly in case you are here on my channel for the first time. My channel is a place that is completely bipartisan. I do not personally subscribe to a political party. I do not have a political party. I'm completely independent. I don't even call myself an independent, capital I. I just really honestly, my God is the truth. My politics is the truth. Okay. So as we're going through this case, the mainstream media is going to try and politicize it. It is going to try and make it seem as though this is an issue having to do with Democrats versus Republicans or conservatives versus liberal people, whatever, what have you. That is not the case. This case is about power, corruption, and greed, and is about controlling young people and women, especially, autonomy and bodies. And so we may end up, exposing some of your personal faves. They may end up being mentioned here. Listen, my God is the truth, okay? The truth is going to be what I am personally in search for, okay? I just want to get that out of the way right now because y'all don't know how to act in the comments sometimes. So be nice to each other. It is we the people united against power, corruption, and greed. And that is what I would like to cultivate here on this channel. Now, without further ado, let's get into this case. Now, many people... Exactly. Belle Stewart, exactly. Good point. This case is already extremely politicized, but the truth is there are criminals attached to this case from both sides of the fence, okay? And from all over the world. We have royals, Prince Andrew implicated here. We have people that Disney, we have people, Republicans, Democrats, okay? Keep an open mind because the truth is what we are in search for on this channel. If you've already made your mind up on this case, get off this channel. This isn't the place for you, all right? Okay, so here we go. All right, so what we're going to be talking about today, and I have the documents also printed out in case they get deleted from the internet. I have a Ghislaine Maxwell, oh God, I know, how do cameras work? I have a Ghislaine Maxwell file here, and the first file folder here is called Little Black Book. We're going to be going over two major filings in the case today, but I will bring them up on the screen so that y'all can see them. They are also below in the description box, linked in my Google Drive. They're linked. You can find these documents, okay, if you need to look at them. Okay. Exactly. Be on your own side. Exactly. I'm on my own side. Okay. So what we're going to be talking about today is something that some of y'all might have heard of before, and it is called the Little Black Book, colloquially, right? And so one more announcement I want to make, and then I'm not going to make these announcements anymore after in this series. But I do anticipate that YouTube is probably going to suppress, demonetize, and censor this particular content because of some of the words that are automatically flagged in the algorithm. So if you want this series to get the attention that you believe that it should be getting, then you may need to actually help me a little bit with sharing the videos and things like that, because whenever YouTube decides something is like against, what they want to be shown, then they can suppress the content, right? And I am working on my own website. I've been working with a developer so that we won't have to worry about this censorship anymore, but this is where we are. This is America as we live in it today. Okay. So what we're going to be referring to today is the Little Black Book. Now, if you want to know a little bit more about the Little Black Book, Yahoo News, even though they are mainstream media, they did do a nice little video that is linked below that will tell you about this book, how it was found, who found it, how it's been authenticated, etc., etc. I'm not going to be going through that here because someone else already did that, and why would I recreate the wheel? So you can click that below that Yahoo News article. So what we're going to be talking about is that Little Black Book. Now, that black book is alleged to be the associates, affiliates, and, friends, family, whatever of Jeffrey Epstein. He allegedly, had dropped it in the middle of the street sometime in the late 90s, and someone found it. Or maybe the early 2000s, someone found it. And, like I said, go to that video below and you'll be able to see what, happened with all that. But there's a lot of names you would have heard of in this book. I'm not going to mention them at this moment, but that book has been digitized, meaning it has been scanned into a PDF, also linked below, also in my Google Drive. Y'all should make sure that you download those onto external hard drives. If you want to make sure that you have them forever. Even more safe option would be to print them out, but it is like 92 pages long. So we're talking about that 92 page long PDF. So first, I'm just going to pull that up. Okay. So y'all behave in the comments. Once I pull these things up, I can't see y'all's comments very well anymore. So I know I do have one of my best mods here. I think I have two of my really good mods here. So thank y'all. Okay. So I'm just going to scroll through the video today is not necessarily about this document, like going through it, but I want y'all to just get a sense of what Exhibit 52 really is. Okay. This is the exhibit. This is what we're looking at. Now what they're actually trying to put into the trial would be the actual book that these pages came from. Okay. So as you can see, there's just all kinds of names. As you can see up here, it's like there are tabs in this book. I don't know who would have put those tabs there, but this is the exhibit that we're going to be talking about today. Okay. So as you can see, we have a few names that have squares around them. Again, I don't know who would have put those squares, but this book is alleged to have belonged to Jeffrey Epstein and is alleged to contain people's names in it who would have perhaps visited his island. It's like his address book, it looks like, right? And they have people's addresses kind of blacked out. Now, if you want to see this document, if you want to go through it, I do have it linked below. It is available on the internet. Now, one thing I did find interesting, since this is a case about censorship in a lot of ways, and that's something I talk about a lot on my channel. There was this Gawker article that I have now printed out. Sorry. And it's, here is, and I don't know if I can say this word on YouTube, billionaire Jeffrey Epstein's Little Black Book. Now, what's really interesting, there's this website called Wayback Machine on archive.com. And it's where you can basically take a website's URL. Thank you, Jordan. It's where you can take a website's URL, like the address of the website, put it in this website, and it'll basically keep a snapshot of the website. So what I tried to do was go and make the Wayback Machine save a copy of this 2015 Gawker article, which does include the PDF to Jeffrey's Little Black Book. And for the first time in a year and a half of me using this website, it was actually blocked. The Wayback Machine said, the URL you're trying to save is blocked and we cannot save this URL. So immediately I printed out the article and I also saved the Little Black Book PDF itself. And I'd never seen that before. So I'm just letting y'all know the powers that be do not want these documents out there. And so I would strongly encourage you to make personal copies for all of these for yourself in your external hard drives. Do not save them on cloud. Save them somewhere off, like on a USB drive or something like that. Okay, so now that is the article that I did get this document from. Now, this is the document at issue. So whenever you're going to see Exhibit 52, this is what they're talking about. They are talking about the address book, or the Little Black Book as it has been colloquially called. Okay, so now I'm going to share with you Ghislaine, I guess is how you say her name, Ghislaine Maxwell's, or Ghislaine. How do you say that woman's name, to be honest? I thought it was Ghislaine. I really don't know. I've heard Ghislaine. We'll go with Ghislaine. I really don't know. Okay. So I'm going to pull up Ghislaine Maxwell's filing, and we're going to read through that together. And then incidentally, the government responded. The Department of Justice has responded to her. So we're going to read their response as well. So let me just get that pulled up right now. Sorry, this is what happens when you go live, y'all. And when you're like an old lady like me and you're not good at technology. Okay. So let's, again, if you're having a hard time reading the font, the text on here, it is linked below. You can find this document all over the internet. So let's just get started. Now, interestingly, as you can see, this was filed on the day of Britney Spears' court hearing, which is why I'm a little late to get to this document. So as you can see, it is called Ghislaine Maxwell's motion in limine to exclude Government Exhibit 52, an unauthenticated hearsay document from suspect sources. Okay, so y'all ready to learn a little bit more about the law? Welcome to That Surprise Witness Academy. We're going to learn what a motion in limine is today. Okay. Oh, also, do you like my new mic stand? I need to get used to it because I like to use my hands and it's a low profile one. Okay, so a motion in limine is when you are asking the judge to make a ruling on a piece of evidence before the trial. So a motion in limine can be used in this particular situation for the judge to make his or her decision on whether or not to allow this little black book into evidence or not. Now, the judge can rule with prejudice or without prejudice. A lot of times, motion in limine ends up getting ruled without prejudice, so that the judge can reserve the right to actually change his or her mind whenever the trial happens. So what Ghislaine is trying to do right here is she's trying to have the judge keep the little black book out of the jury or the judge's eyes in order to basically, not be able to, so the government cannot use that evidence against her. Okay. So it looks like, based on the title of this document, her legal reasoning is going to be the reason this should be kept out of court is because it's not an authenticated piece of evidence and it's hearsay, right? Unauthenticated and hearsay are very important because in the United States justice system, we have this strong notion of due process and innocence until proven guilty. And a lot of these rules are really good, and a lot of them are a little bit, I call them perverted because it's kind of like a perversion of a sense of justice. So it seems like what Ghislaine, and we're going to read the document together, is about to try and argue is that because this is not authenticated, because, we don't really know the origin of this little black book, people could have, added things in, taken things out, changed things around. We don't really know where this came from. Also, a whole nother notion that's very important here is the concept of hearsay. Now, hearsay is an out-of-court statement that is used in court in order to prove the truth or the falsity of the matter that's asserted. And so essentially, the reason that we don't really want to have hearsay evidence brought into court is, why would we take somebody else's word for something when we could ask the source here in court? You know what I mean? We have to be able to ask people stuff under penalty of perjury. We have to ask people stuff after they've sworn on a Bible or sworn on whatever, that they have tested this evidence. And so because it's unauthenticated and because it's hearsay, Ghislaine Maxwell is arguing we should just not allow anybody to see this book, I think, right? So let's read and see. So we have the table of contents. The document cannot be authenticated. Now, a lot of times you have this counter argument where if a document can't be authenticated in a traditional sense, as long as it's a business record that was kept for the purpose of doing business, in the ordinary course of business, like invoices, there's stuff that comes to mind, right? Like board of directors meeting minutes, those are documents that are kept in the ordinary course of doing business. And so a lot of times, even if they are, if somebody tries to argue, oh no, that's hearsay, then you can get out of it being hearsay by saying, no, it's a business record, right? So business records can always come in is kind of the notion of the trial world. Okay. So now we have the cases that they're going to cite. And the exhibits, Government Exhibit 52. Now, that is the document that we have already kind of scrolled through earlier, right? That little black book that has been scanned into a PDF, but they're talking about the actual book itself. And then they're going to also include in as their exhibits a deposition of this guy, Alfredo Rodriguez, on August 7th, 2009. Okay, so now that all that's out of the way, I'm not going to do these disclaimers every time, but this is a brand new case. Okay. Okay. All right. Introduction. Okay. Let's start up here. Defendant Ghislaine Maxwell, and they're going to call her Miss Maxwell, files this motion in limine to exclude Government Exhibit 2. So she files this motion for the court to determine before the trial actually starts, not even to let that stuff come into evidence. Okay. An unauthenticated hearsay document from suspect sources, and then it states as follows. So defendant states as follows. So this is what Ghislaine has to say. The government has identified as Exhibit 52, A through F, pages of an often photocopied and altered exhibit that has no identified author, date of creation, or custodian. These pages are from a 97-page exhibit provided to the government from lawyers who represent multiple Epstein accusers, aka victims. Now, there was a big, free-for-all in this case over whether or not we could call these minors who were abused and trafficked victims, right? And so we're still seeing Ghislaine Maxwell's lawyers refusing to refer to them as victims, and instead, they are referring to the Epstein victims as accusers, okay, which I think is just important to see which words that people are actually using in cases like this. The document, as produced to the government, is attached as Exhibit 1. And y'all can, again, that is available in the link below. You should be able to get it from my Google Drive in the Maxwell Epstein folder file for free. You should be able to access that for free. As produced, the document appears to be a compilation of material that was copied from more than one source, arranged and paginated after the fact. There are unexplained faded marks that may have at one time been staples or evidence of staple holes. The top page of the top of page 1 of Exhibit 1. So he's saying the top of Exhibit 52, right? They're calling it Government Exhibit 52. Very confusingly, they're referring to it as Exhibit 1 in this particular file, but Exhibit 1 and Exhibit 52 in this particular video right now are the same document, and that is that little black book, okay? So if you see Exhibit 1 or if you hear me say Exhibit 52, we're talking about the same thing, okay? So as produced, the document appears to be a compilation of material that was copied from, okay. The top of the first page of the exhibit has 6 faded dots that look like a photocopy of a page that has 3 staples removed. Page 4 has shadows that resemble a page that was photocopied with staples in the page. It is impossible to tell whether pages have been added, omitted, cut, or pasted. There are several examples of what appear to be photocopies of tabs, which suggest that pages have been added, omitted, or altered because of the inconsistency from page to page. For example, tab-like shadows appear at page 20, but not on page 21 through 23. They reappear on page 24 and disappear, and reappear within the remainder of the exhibit. At certain points, pages 78 and 79, for example, the tab-like shadows appear to be covered by something. The government's compilation has been cleaned up from what was produced from the civil litigation. However, no one can clean up the unsavory story of this purported exhibit. Okay, so basically what this lawyer is saying is, we don't know even if this is a book. They're trying to introduce this PDF, but what's all these pages about? What's these staple marks about? What's these tabs about? Now, from the one side, I'm kind of like, ew, why would you try and protect her? But because my God is the truth, I have to consider the devil's advocate alternative, which is perhaps there are many names that were left out of this book that someone somewhere is trying to hide. And I do want to make sure, and I personally, y'all can have your own opinion, but I personally do want this document to be authenticated because I want to know for sure that this is the full story. I'm not trying to say, oh, because Ghislaine is innocent. No. I'm saying whose names was left out of there if any names were left out of there. Do you see what I'm saying? Okay. The document was not produced pursuant to any subpoena from a legitimate third-party custodian. Rather, the document appeared as part of discovery in the Jeffrey versus Maxwell civil litigation case with no explanation about its origin. Again, there is a video linked below in my description box that is to a Yahoo News article. In that Yahoo News article, it links to a video that does tell you how this book came to be in the possession of, the powers that be, et cetera, et cetera. And there was a civil litigation. Now, what we're talking about right now is a criminal trial being put on by the government. That is what is starting on Monday. That is what we're here today talking about in this video. But as you know, Jeffrey Epstein and Ghislaine Maxwell have been involved in other litigation relating to these same allegations. And in those lawsuits, one of them was brought by actually a victim of Ghislaine and Jeffrey Epstein. And that was Virginia Jeffrey. Okay. So in that case, Virginia brought up this little black book as evidence. And this lawyer in this current case is saying, okay, but they didn't explain the origin of the book. So basically, this lawyer is trying to say, because the origin of this book was not explained, and because it's got all these discrepancies about where there's pages and staples and tabs and et cetera, it shouldn't be allowed to be used, is what it seems like their argument is going to be. The provenance of this exhibit is particularly troubling. I don't know what provenance means, sorry. The document compilation allegedly surfaced in connection with a former Epstein employee, Alfredo Rodriguez, now deceased. Oh God, they done killed Alfredo? I need to look into how that man passed. Mr. Rodriguez was attempting to sell the compilation to Brad Edwards, one of the lawyers who was involved in suing Mr. Epstein in 2009. Okay, so in 2009, this guy, Alfredo Rodriguez, was trying to sell this book to a lawyer who was actually suing Epstein. And now that Mr. Rodriguez is dead. So I find that to be particularly troubling, and I would like to know more details into how he passed away. According to the criminal complaint filed against Mr. Rodriguez in 2009, he approached one of the lawyers and offered to sell the lawyer evidence against Mr. Epstein. A sting operation was set up by the FBI, during which the 97 pages were provided to an undercover officer in exchange for $50,000. Oh, that's interesting. So this is the alleged origin of this particular little black book, according to Ghislaine Maxwell's lawyer. It is unclear, and again, we should probably look into this case. I have not heard of it. I have not looked into it, but I do believe we will be able to look into it if y'all want to. It is unclear what the government claims these documents are. What is clear, however, is that they are neither authentic nor relevant. Well, okay, listen. It is unclear whether they're authentic, but what this lawyer is trying to say in this filing right here is it is clear that the documents are not authentic. And that's not true. That's a lie. It's not clear that they're not authentic. It's just not clear that they are authentic either, right? We're kind of in a gray area. What happens at trial is they will need to bring in an expert who can authenticate it, right? They might look at the book and say, well, look, this was printed between this year and this year, this handwriting, what, you need an expert to come and authenticate a document, but this lawyer is not an expert. So he cannot authenticate this document. He's not familiar with it. And so for him to say that it is clear that the documents are not authentic is a bold-faced lie. It is also obvious that the documents are hearsay. Now, that is true unless there's a hearsay exception. Now, if that's going over your head, that's fine. Don't worry about it. But if it's not, remember from earlier whenever I said, business records can come in and kind of trump, no pun intended, the hearsay rule. So it's like hearsay, here's the door, here's the gate keeping stuff out of court. And here comes some hearsay. Oh no, you can't come in here. So the gate would keep that hearsay out of court. But what if another lawyer came around and said, it's not hearsay, it's a business record? Well, then that gate falls and then that record can come into court, right? So this guy or this person, this lawyer is saying it is so obvious that these documents are hearsay because it's an out of court statement and it's offered for the truth of the matter asserted in violation of Federal Rule of Evidence 801. There's no witness who can identify or attest that these documents qualify for any exception to a hearsay rule. Remember I told y'all about those exceptions just a second ago? So this is where that expert would come in. An expert would have to come in and say, this is why I know it is real. Their lawyer, Ghislaine, Maxwell's lawyer in this filing, is saying there is no such expert. We can never authenticate these documents. And for that reason, it should be kept out of court. Given their unknown date of creation, thank you, Lisa. Given their unknown date of creation, the lack of any authenticating witness, the fact that the documents do not appear until 2009, 5 years after the end of the conspiracies charged in the indictment, there is no relevance that can be attached to the information. Okay, I don't know if that's true, but these are the rules, or her. I don't know if this is a he or her. But this is the lawyer's legal arguments they're relying on. They're saying, look, there's no witness. The documents don't show up till 2009, and that's weird because all the indictments that we're talking about here are from 5 years before that, right? Or they all ended 5 years before that. There's no relevance, right? So they're irrelevant. And so because of that, there's no relevance. And because of that, we should keep it out, is what he's saying. Moreover, any arguable relevance. So look, this is what lawyers like to do, and it's really annoying. There is no relevance. Okay, well, if that was true, then the next sentence would be completely unneeded. But here we go. Moreover, so like, never mind what I just said. Any arguable relevance is outweighed by the prejudicial considerations, right? So one rule of evidence, if you're here to learn the law, is that evidence submitted at trial must be relevant. It must help to answer the question of truth, right? Thank you, Heart of Inspiration. You are always so nice. And you're welcome. It's my pleasure to explain this. I believe we the people should know what's going on in our institutions, and that is what I'm here to do at 10-12 a.m. on a whatever the day of week is morning. Okay. So what he's saying here is any arguable relevance of this evidence, right? So even if it is relevant, which I already just now said it wasn't relevant, right? He's like, oh, well, it's not relevant. But even if they try to argue it's relevant, we still got to keep it out because it would be so prejudicial to this alleged and accused trafficker that it would be unfair, right? And I just got to tell y'all, my personal opinion is I don't really want a trafficker to really be treated all that fairly. But I acknowledge and recognize that we have to keep the justice system fair across all defendants, because sometimes it might be a defendant that I do want to be treated fairly. And who am I to just pick and choose who gets to be treated fairly, right? So we have these rules that have prejudice and relevance, and they kind of balance on a scale. And a judge can sometimes say, look, this is so prejudicial, this is so harmful to the defendant that any potential relevance would just be outweighed by the harm. Like the jury would not fairly be able to clearly see this. Now, usually I'm in favor of keeping evidence in, but sometimes I do see reasons to keep it out. In this case, I'm not convinced quite yet that it should be kept out, but we'll see what the government responds back, and we'll see the rest of this filing. Okay. It is unclear and unknown who created the documents, when they were created, or how they were created. The documents cannot be authenticated, and no evidentiary foundation exists that would allow for the admission of the documents. Now, this sentence I'm a little sympathetic to, but the following sentence I'm not, right? So it's unclear and unknown who created the documents, when they were created, and how they were created. If that's true, then maybe they shouldn't come into court, right? Because I guess I don't want to live in a world where anybody can just type up anything and say, oh, this is evidence against you, right? Because the way that our justice system works, and what y'all have to understand, is our justice system, both civil and criminal, relies on the concept of precedent. So what was decided in a case before is now law, right? That's the way that we make law. And so in this case, we might really like it if they just throw the book at her and do all these unfair things and all that. We might love it. But tomorrow, somebody that we actually like, somebody that didn't do anything wrong, might be on trial. And then what? You know what I mean? So we have to make sure that we keep these rules in place for whenever it is people like, me or you could get accused of anything. And we need to make sure that there are safeguards in our justice system to protect innocent people. That is not me saying that Ghislaine Maxwell is innocent. I believe she's probably not. But we still have to go through the way that the court works. I mean, listen, I'm a lawyer. I'm not a vigilante. I'm not a mercenary. I'm not in any militia. I'm a lawyer. And so I really have to use the law to kind of fight the law. Now, sometimes laws don't make sense, but I think the rules of criminal procedure should protect defendants for the most part, because in our society, you are innocent until proven guilty. But in my personal opinion, Ghislaine Maxwell is not innocent. But I try to keep it from the both sides so that this is really fair representation, so people aren't blindsided like, well, that surprise witness said. I'm just telling y'all how it's probably going to go in court. You know what I mean? Okay. Thus, who or who may not be the author of whatever ended up as these photocopies is not evidence that can or should be considered by any jury in this matter. Now, what I think is interesting is he's just talking about photocopies and he's not talking about an actual little black book. I'm wondering if all these arguments would still hold up if somebody showed up and said, here's the actual book. Do you know what I mean? The document cannot be authenticated. So here's their first argument. In order to satisfy the requirement of authentication, a party must provide evidence sufficient to support a finding that the matter in question is what its proponent claims. So they start off with the rule. Okay, so here's the rule of evidence 901A. And it says, in order for documents to be submitted to the court, they need to be authenticated. And in order to be authenticated, you have to provide evidence that supports the notion that the document is what it claims to be, right? So if you're claiming that this is Jeffrey Epstein's little black book, you have to provide evidence somehow, some way. Maybe you have a picture of Epstein with the book, or maybe you have his assistant who's not dead, unlike Mr. Rodrigo, who shows up and says, no, that is definitely the book. That's my handwriting in the book. I wrote in the book. I know this book, right? Like you have to have some evidence that shows it is actually Epstein's book, right? It is what you are claiming it is, right? Rule 901 is satisfied if sufficient proof has been introduced. And here's the standard, so that a reasonable juror could find in favor of the authenticity or identification. Like the examples I just gave, right? You need somebody that's been there, done that, seen it, somehow, some way, like some way to place that evidence in the possession of Epstein and say that is what you're trying to say it is. Here, the putatively proffered documents, so here, the exhibit that we're talking about, were at the heart of Mr. Rodriguez's bribery and obstruction scheme. So they're saying, look, listen, Mr. Rodriguez, that former assistant where these all came from in the very first place, he was literally bribing and obstructing, and he got actually found guilty of accepting payment in a bribery scheme for these exact documents. And so the lawyer then says these documents didn't surface till 2009, which was decades after the claims that are made in this lawsuit. Years after the alleged conspiracy, and 5 years after that assistant was no longer working for Mr. Epstein. The documents contain an unexplained notation that says PB 2004-2005, the only potential hearsay date referenced in the documents. Only potential date referenced in the documents is PB 2004-2005. I don't know if that means President Bush. I don't know. What is PB? Does anybody have any theories? I really don't know. There is no evidence to suggest these documents were created or maintained by Ghislaine Maxwell or Ghislaine. I really don't know how to say her name. Sorry if that's your name and I'm saying it wrong. No, I'm not sorry to actual Ghislaine, but if you happen to also have that name, sorry if I'm saying it wrong. If I'm saying her name wrong, I could literally not give two. It is entirely probable that whatever the documents are, they were manipulated or manufactured by, okay, so this guy's saying, okay, listen, they like to say entirely probable to make it sound like their words are like stronger than they really are. But again, this is basically the same, this is virtually certain right now. What it means is possible. So there is a chance that these documents were manipulated or manufactured by that guy, Alfredo Rodriguez, in an effort to get his $50,000. And then they do cite that case again. Mr. Rodriguez explained that he had compiled lists of additional victims in the case and their contact information. Mr. Rodriguez's statement, albeit inadmissible on this issue, is that he did not possess any document, list, books, journals, or anything else taken from Mr. Epstein's home. Okay. And then they redacted all this stuff, so we can't tell what it actually says. To be clear, the 97-page exhibit is not, okay, to be clear, the 97-page exhibit is not a document that was given to Detective Rissery. I don't know what this is referencing because there's all this like blacked out stuff that I don't know what it said before. So now, remember that hearsay exception? Like, here's the gate, and you can't get in if you're hearsay, but if you have an exception, the gate lowers and you can get in. That's the evidence we're talking about here. So they're saying one of those exceptions that would lower the gate and let the evidence in is if it's a business record. So they need to argue here that it's not a business record, because if it's a business record, it comes in and the jury can see it. If it's not a business record, then they can keep saying it's hearsay, and now they can argue on whether or not it should come in, blah, 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 if that makes sense. PB may mean phone book. Oh. Okay. So I do want to just highlight real quick. Book of clients, client book. What are y'all saying? Hold on. So Simply Manka, thank you for this piece of info. This is a good clarification point. People that visited the island, I think, are on those flight logs, and not all of them are clients, but it's the biggest lead to who participated. So I'm not exactly sure what they are trying to say that this book actually is. And we will see the government's response in just a moment. But yeah, Steve, PB may mean phone book. So PB 2004, 2005. Okay. So let's go to the document is not a business record. Again, they have to argue that document is not a business record so that they can continue to say like it's hearsay, because hearsay is by default not going to be allowed in the court for the jury to see. So in addition to there being no witnesses to authenticate the document, because Mr. What's-His-Name has now died somehow, it is clear that the pages of putative exhibit 52, putative means they trying to make it 52, but we trying to make it not 52, so it's not for sure 52 yet. You know what I mean? No witnesses can authenticate the document, and it is clear that the pages were not a business record, and there is no record custodian who can establish a foundation for the administration of the document under the federal rule of evidence. So they're basically saying, we don't want to hear that they're trying to argue it's a business record, because it's not a business record, and these are the things it would have to be a business record, and it just doesn't meet those requirements. Mr. Rodriguez apparently gave something to federal agents in 2009. Someone, perhaps Mr. Rodriguez, created the document. Mr. Rodriguez was convicted of trying to extort money from lawyers representing plaintiffs against Epstein. Okay. This one-off document is far from a reliable business record. There's simply no evidence to suggest that this document was created in the course of any business. Rather, the exhibit was specifically prepared in anticipation of litigation against Mr. Epstein, and therefore is not a business record, right? So if something is prepared for the purpose of litigation and not in the ordinary course of business, by law, it's typically not going to be considered a business record. Records prepared in Yeah, I just read that. Records prepared in anticipation of litigation are not made in the ordinary course of business, right? Man, I sure did study hard for that bar exam. There's like stuff I can still recite by heart. Reports prepared for the purpose of litigation do not fall within the business records exception to the hearsay rule because they are not kept in the ordinary course of regularly conducted business. Setting aside the fact that the document was prepared for a criminal purpose, and that would have been bribery and extortion, to be admissible as a business record, the proponent of the document must establish the source of the contested information. That is, 1, the author of the document had personal knowledge of the matters. 2, the information he reported was transmitted by another person who had personal knowledge acting in the course of regularly conducted activity. Or 3, it was the author's regular practice to record information. Okay, so these are the 3 ways that it is a business record, and they're basically saying, and none of those 3 things apply here. In addition, the proponent, that's like the people trying to put the stuff into evidence, must establish the information was kept in the regular course of the author's business, and it was the author's regular practice to prepare these reports. Okay, there is no evidence on any of these issues, and accordingly, the document is hearsay, for which no exception applies. And then we have the lawyers, interestingly, in a Colorado law firm, Jeffrey Pagluka. And then we have Cohen and Gresser, law offices of Bobby Sternheim. Okay, let's see what else we have here. Who are these people? Okay, so here's the U.S. attorneys that are working on this particular case. Interesting. Okay, so let's turn now our attention to the government's response. What are y'all thinking about that so far? Interesting. Okay. Yeah, exactly, Steve. This proves again, if you have money, you get the courts to be fair. If you are not rich, then the law can be used against you. 100%. 100%. Oh my gosh. Are you serious, Sassy? There was an article about the NYPD being the ones who were lacing drugs with fentanyl, but she can't find it anymore, or they can't find it anymore. Okay, so now we're going to turn to the government's response, which was filed just one day later. Okay. Okay, so this is a letter filed the day after the one we just read, November 13th. And it is a letter that was sent to the judge, Allison Nathan. We should probably look into her and make sure she's fair and all that. So they have... Okay, and they've dated it November 12th. So it was filed, like, as soon as they read that thing from Ghislaine, they went ahead and filed this. Now, usually I'm not going to be on the side of the government, but I am going to be on the side of going after an alleged trafficker. So I guess, even a broken clock is right twice a day, and we'll see what they actually have to say in here. The government respectfully submits this letter regarding Government Exhibit 52, a contact book belonging to the defendant, which includes, that's her, Ghislaine, which includes contact information for, and then they're going to block out the name, which I don't think they should be blocking out people's names. This should be publicly available information, so they should not be redacting that. At the November 1st, 2021 conference, so there was apparently a conference on the 1st of the month, the court requested additional briefing regarding this evidence. The defense, that's Ghislaine, has moved to keep this evidence out of court, right? Preclude this evidence, arguing it cannot be authenticated. So that was the document we just read, right? For the reasons set forth below, they are wrong. Testimony at trial will establish that Government Exhibit 52 is in fact a contact book that belonged to the defendant. Okay, boom. All right. So if you remember, just a few minutes ago, we read Ghislaine's lawyer saying, I need a new cover windscreen for my mic because I'm definitely allergic to it. Or I should put something over it or something. I don't know. Okay, so if you remember a while ago, just a few moments ago, we read Ghislaine Maxwell's lawyer say no one could possibly authenticate this document. And because of that, we got to keep it out. Well, here comes the Department of Justice saying, wrong. Testimony at trial is going to authenticate this document. So it will establish that it is in fact a contact book that belonged to Ghislaine Maxwell, and the fact that she kept contact information for blanked out name is compelling evidence of her guilt. This evidence should be admitted. Background. Government Exhibit 52 is a printed bound contact book containing dozens of pages of contacts, including family and friends of the defendant. Family and friend of Ghislaine Maxwell, okay? The entire book is marked for identification as Government Exhibit 52. And the government anticipates asking a witness at trial about the book, specifically an individual who worked for Jeffrey Epstein, employee number 1. However, the government does not intend to offer the full contact book in evidence, okay? Instead, the government anticipates offering only specific excerpts from the book that relate to the conduct charge in the superseding indictment. That's the crime she's been accused of. Those excerpts have been marked as Government Exhibits 52A through 52F. and were produced to the defense on October 11th. Okay, we have a footnote. These exhibits were marked in advance of the court's rulings in limine. In light of the court's rulings regarding evidence offered under Rule 404B, the government does not intend to offer the case in chief certain excerpts. Okay, so what this is saying is, look, listen, maybe there's parts of this book that we have to keep out, but there's certain parts of this book that we want to keep in, and we should be allowed to do that. Most notably, Government Exhibit 52G, which the government intends to offer, contains, look, most notably contains, and then it's just blacked out. So the public cannot see what the most notable. This is just so infuriating. Most notably, and then we don't know what's the most notable part, but I mean, here we are. Welcome to America. Employee 1 is expected to testify. So this is that employee. They're going to bring employee 1 in, and employee 1 is going to tell that this is the book for Ghislaine Maxwell. Here's the reasons why, etc., etc. That employee is going to testify that while working for Epstein in some year, employee 1 was aware of 2 sets of contact books maintained in Epstein's residences, both of which were printed and bound in a distinct format. Okay, so y'all remember earlier when I was telling y'all, yeah, there's someone who can say, I saw that book, I dealt with that book, whatever. That might be enough. And here we have it. It's, prophecy coming true. Employee 1 will testify that multiple copies of each book were kept in various locations, including at Epstein's Palm Beach residence. The first book belonged to Epstein. The second was a small bound book, which was commonly referred to throughout the residence as the defendant's book. Okay. There were multiple copies of that book in the Palm Beach residence, and employee 1 recalls seeing a copy in the defendant's office in the Palm Beach house. Employee 1's account of the 2 different contact books is corroborated by evidence that we have in the documents. In particular, the household manual. The household manual. Oh, wow. This is really interesting. Okay. In particular, the household manual, in effect, during the same year that employee 1 actually worked for Jeffrey Epstein, instructs employees to make sure that a copy of Mr. Epstein and Miss Maxwell's telephone directories must be placed to the right of each telephone, except the guest rooms. So there was guest rooms in the house, but every telephone that wasn't a guest room had to have one of those little address books right next to it. G.E. Jeffrey Epstein and Ghislaine Maxwell telephone directories are to be placed to the right of telephone and check-off list for pre-arrival preparations. And their telephone directories in vehicles and bicycles section, and placed to right of the telephone for Miss Maxwell's desk. So this is all from the household manual. Man, I should write myself a household manual and hold myself to it. Maybe I'll get something done. Put in a manual. Y'all believes that household had a manual? His vacation homes had manuals? What on earth? Employee 1 has examined Government Exhibit 52 in preparation for trial. This is, that PDF that is linked below, and recognizes it to the defendant to be the defendant's contact book. So that employee, now we're having the Department of Justice say, hold on. We got an employee that worked for them during that year saying that is actually Ghislaine Maxwell's book. And so they're willing to come into trial and testify to that fact. Copies which were maintained in Epstein's Palm Beach residence, among other locations. Employee 1 recognizes the shape, color, binding of the book, and recognizes the formatting and style of the entries as consistent with the manner in which the defendant's book was organized and the way in which entries appeared. Employee 1 also recognizes several of the contacts listed in Government Exhibit 52 as friends of the defendant and Epstein. So not only does the guy or the person, the woman, I don't know, employee number 1, who's going to be a whistleblower, not only does this employee whistleblower recognize the book, its actual self, but when you open the book and read what's in it, this whistleblower actually also notices and recognizes family members of Ghislaine Maxwell and Jeffrey Epstein. And friends. Wait, no, just friends. As friends, not family. I don't know why I said family. Sorry. The entries include, among others, that's why I said family members. Ghislaine's family members. Okay. So now they're going to go into the authenticity. Now, y'all already heard what Ghislaine Maxwell's lawyers had to say about the authenticity of this document. Now we're going to see what the Department of Justice has to say about it. As a general matter, an item of evidence must be authenticated through introduction of evidence sufficient to warrant a finding that the item is what they're trying to say it is. Okay. We already went over that standard. Under Rule 901 of the Federal Rules of Evidence, the requirement of authentication as a condition precedent to being able to admit something into evidence is satisfied by evidence sufficient to support a finding that the matter in question is what its proponent claims, which we already went over this standard, so I'm not going to go into that even more. This bar for authentication is not particularly high. Okay, so how high is the bar? Like, how high is the threshold you have to actually get over to get your document into evidence, right? Well, not that high is what the Department of Justice is saying. We should be able to get this in. To meet the burden, the government, here's what do they have to do to meet their burden, to get over their threshold? The government has to introduce sufficient proof so that a reasonable juror could find in favor of it being authentic. For a document attributed to the defendant, the prosecution only needs to provide a rational basis from which the jury could infer that the document did in fact belong to, in this case, Ghislaine Maxwell. So the courts have already decided in cases before this that to provide that in order to get the evidence into court, really you just have to show a reasonable, reasonable thing, like a rational basis. Like, is it rational that this is, that this is the book? So the government's saying, like, this is really not a high bar. Evidence of authenticity may be direct or circumstantial. So you don't need direct evidence. You can go on, if A, then B, if B, then C, C is there, so A. You can go on that type of evidence. And the latter category may include distinctive characteristics of the document itself. So you can admit circumstantial evidence, right? You can say there's circumstantial proof that basically describes what the document looks like, who had written on it, maybe there was a coffee stain on it, something like that. Like, that is circumstantial evidence that it was the document in question. And all you got to do is put circumstantial evidence before the court, and they're going to let that document come in. And it is because we have a system in the United States that allows the evidence generally to come in. If it's relevant, the jury should be able to hear it, and then there's these exceptions and exceptions to exceptions. But if it's relevant, common sense, the jury should be able to hear it. And it is relevant if there's circumstantial evidence that can prove that it is, probably what the person who's trying to get it into evidence is saying that it is. Indeed, Rule 901 contemplates multiple avenues through which a proponent, one party trying to get the evidence in, through which they can authenticate the evidence. For example, the proponent may offer testimony that an item is what it's claimed to be. So testimony is good enough. May offer evidence of the appearance, the contents, and the substance of internal patterns or other distinctive characteristics of the item, and it should be taken together with all of the circumstances. Here, the testimony of that employee establishes the authenticity of the exhibit. In particular, the fact that employee recognizes this exhibit, can identify it as the exhibit's contact book based on its distinctive characteristics, is all that Rule 901 requires. So this is what you have here. And the government is saying we've already met that burden. Indeed, the Second Circuit has affirmed the admission of evidence under similar circumstances, whereas here, the government does not offer evidence at trial about how the exhibit, came into the government's possession. In United States versus Al-Faraq, the defendant argued that the government had failed to establish the authenticity of handwritten letters that were found in a USB drive that was handed to an agent of the Federal Bureau of Investigation in Afghanistan. So in that case, they're using a case as precedent to be an analogy. And they're saying, look, there were handwritten letters that were actually scanned into PDF and found in a USB drive, and it was handed to an FBI agent. The Second Circuit rejected the challenge. So the Second Circuit let the evidence come in. And what they said, the court said, was although the government did not present evidence regarding the circumstances surrounding the seizure of the USB drive, Federal Rule of Evidence 901 permits authentication based on the appearance, the contents, the substance, internal patterns, or other distinctive characteristics of the item taken together with all the circumstances. So if y'all remember when we read Ghislaine Maxwell's lawyer's thing a few minutes ago, what they were saying is, oh, they got that book from some criminal and we don't even know how they turned it over, how they even came into contact with it. Oh no. Well, basically the government's saying, too bad, so sad. That don't make no difference to me, because the federal rule doesn't require I tell you how I got it. The federal rule only requires if I have it, somebody can authenticate it and through their testimony. And too bad, so sad for you, Ghislaine. We have somebody who's willing to do that. We don't have to prove how we got it, where we got it. We don't have to prove that the source of the document was good. All we have to do is prove that it's real, and we are able to do that. So that's the government's argument. Witness testimony about the content of the letters in that case in the Supreme Court, or in the Second Circuit that we're going over, witness testimony about the content of the letters was sufficient to pass the test because it's a relatively low bar for authentication of evidence. Again, low bar. It's not a high bar to clear because we want to let in all the relevant evidence to let the jury make the fair decision and arrive at the truth. This is not about sides. This is about the truth. Okay. So the government's saying, we already have that, right? The Second Circuit explained that any remaining questions as to the reliability of the letters go to their evidentiary weight, not to their admissibility. So what this means is, in order to get something in just for the jury to even lay their eyeballs on it, it's very low bar. We talking down here, like neck level, here's the bar. But if it's like, okay, yeah, you got it from some shady person and they're not really able to authenticate it and maybe it came from a criminal, well, the jury is allowed to weigh that evidence accordingly, right? So let's say it ends up being found out that the guy who originally made these documents was like a total criminal and maybe he wasn't credible or whatever, right? But then you have this employee who's still alive and well, willing to testify that is Ghislaine Maxwell's book. Well, that's the admissibility, right? That admissibility means, can you bring it into court? Can the jury put their eyeballs on it? Can they hear it? Can they look at it, right? If the answer is yes, but then later we find out that witness who testified on it wasn't really credible, maybe they lied about some other stuff, then later in the jury deliberation room, then they can say, you know what, I don't really want to give that little black book a lot of weight because I think the guy who wrote it is a liar, right? But we have to give that evidence to the jury. It is admissible. But that doesn't mean the jury has to say, oh, that's the most important evidence in the trial. This is it right here. Case closed. No, the jury is allowed to use their common sense and say, look, I don't really trust the guy that this book came from. But that doesn't mean that the book gets to get kept out. The jury is the one who's supposed to decide about how much weight to give that evidence based on the source. I hope that makes sense to y'all. I really hope that makes sense. I don't know how else to explain it. Okay. So they're saying, look, just like in that case, same is true here. The employee here is going to identify that Exhibit 52 that we looked at already is the defendant, Ghislaine Maxwell's contact book. He's going to do that. He's going to identify it based on its appearance and based on what's inside the book. Moreover, his testimony or her testimony will be corroborated by the contents of the book itself, which include contact information for Ghislaine Maxwell's family, contact information for victims who interacted with the defendant during the period of time that is at question. That is more than sufficient to establish the authenticity of the exhibit under Rule 901. To the extent the defense disputes employee one's testimony or takes issue with the circumstances under which that exhibit came to be in the government's possession, those arguments are for the jury, like I just said. So let's read this footnote. It is a matter of public record that in 2009, an employee of Jeffrey Epstein, Alfredo Rodriguez, attempted to sell Government Exhibit 52 to a plaintiff's attorney. The attorney contacted the FBI, and agents seized Government Exhibit 52 from Rodriguez, who was arrested. Okay, so in 2009, this employee of Epstein wanted $50,000 for the little black book, or for the address book. And the attorney that he tried to basically get that money from contacted the FBI. And then the FBI agents went on ahead and took the book, away. And now we all can see the PDF of it. And then that guy got arrested as well, Alfredo. And now he's dead, which I don't know how that happened. Government Exhibit 52 has remained in the possession of the FBI since that time. So the FBI has it. Oh, I'm sorry. I skipped a whole sentence. Rodriguez has stated he took the book from Epstein's Palm Beach residence during his employment for Epstein from 2004 to early 2005. And maybe that's why it said PB 2004-2005. It might have been phone book, right? Government Exhibit 52 has remained in the possession of the FBI since that time. Rodriguez, this guy up here who's now dead, pleaded guilty to obstruction of justice and acknowledged that he was obligated to turn his evidence over to the FBI years earlier when he was interviewed during the course of the FBI's investigation of Epstein. It's the United States versus, I want to read this case because it keeps coming up. Rodriguez passed away following the conclusion of the criminal case. How? I mean, that's really strange to me. That guy is dead. Nothing about those circumstances affects the admissibility of this exhibit. Instead, if anything, they cut in favor of them being authentic. If Rodriguez had fabricated Government Exhibit 52, then he wouldn't have been guilty of obstruction of justice. Oh, that's a great point. Good point, Department of Justice. Maybe y'all should do this on all the cases that you're trying instead of just this one. But the opposite had happened. Rodriguez admitted that his evidence was genuine and he was guilty of obstruction of justice for concealing it. Okay. So basically the argument here is, if this was fake evidence and it was inauthentic, Ghislaine, why would the government find this guy guilty of obstruction of justice if he was hiding fake evidence? Like, they would have charged him with something else, forgery, right? Or something else, right? I don't know. I think it's a great argument. Okay. The anticipated testimony satisfies Rule 901 and the evidence should be admitted. Now they're going to get on to the relevance. Because remember, I told y'all, if evidence is not relevant, it cannot come into the case. Here they're going to argue about relevance. Federal Rule of Evidence 401 defines relevant evidence as evidence that has any tendency to make a fact more or less probable than it would be without the evidence, provided that the fact is consequent. Okay. Relevant. So they're giving us the definition of relevance. Like, does it have any tendency to make the fact that you're trying to assert, right, that this lady is a trafficker, does this evidence have any tendency to make it more likely or less likely that she is a trafficker, right? Because that's what she's being accused of. So I think, yeah, it's totally relevant. I mean, to me, it's totally relevant. Her address book around the time of the crimes or the alleged crimes. Relevant evidence is not confined to that which directly establishes an element of the crime. Okay. Is not confined to that which directly establishes an element of the crime. So they're saying we're not even using it. They're saying we're not even using it to establish the actual relevance of the crime, of an element of the crime. So as the Second Circuit has explained, to be relevant, evidence need only tend to prove the government's case. And evidence that adds context and dimension to the government's proof can have that tendency. So they're saying, look, we can include anything that just adds texture and context. Like, if we need to add context, like who were the people they were running around, how far does this ring go, et cetera, that's relevant. Government Exhibit 52 is plainly relevant. The specific excerpts from the exhibit that the government seeks to offer include the names and contact information of blank, 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 gotta cover up the, associates. The presence of those names and phone numbers establishes that the defendant possessed contact information for other people who we don't know, which is, of course, significant relevance to this trial. So maybe it's like Prince Andrew or something, I don't know. This evidence thus demonstrates that the defendant, in fact, knew whatever, we don't know. I mean, it really annoys me to have to read all this redacted stuff. I don't know what it says. Moreover, with respect to several of the contacts listed in blah, 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 which support an inference that Ghislaine knew that at least some of these individuals were minors. So what they're purporting to be able to prove is that maybe Ghislaine is saying, I didn't know any of them were minors. I thought they were all over the age of, 18 or 21 or whatever. And so maybe they're trying to prove, the government is trying to prove in the case, no, she knew they were young, because a big element of this is that she was trafficking minors. So they need to prove she knew they were minors, right? Because a lot of times, what do these abusers and, freaks and criminals say? Oh, I didn't know how old she was. I didn't know. Like, okay, well, she knew how old they were, and these are the reasons. And then, they're blacked out, so we can't see. So I don't know what it says. While employee 1 did not see Ghislaine's contact book until whatever year this is, the contents of the book make it plain that it contains information gathered previously during the course of the charged conspiracy. By its very nature, a contact book that collects phone numbers for many people is not the sort of thing that is generated in a single day. Like the digital contact list is the ordinary modern cell phone, a directory represents a collection of information and numbers typically gathered over a period of years. So they're saying, like, y'all remember Ghislaine Maxwell's lawyer was like, oh, well, this book didn't even come up till 2009. And all this stuff is supposed that we're accused of happened before 2005. So it's irrelevant. You can't bring it in. And then the Department of Justice is saying, no, you dumb shit. This is a book of addresses. Maybe the address book started getting addresses in it in 1992. And maybe in 2021, they still adding addresses. So what year it came out is kind of irrelevant to us using this, right? I hope that makes sense. Okay. Based on this alone, the jury could readily infer that the exhibit, which was seen by employee 1 in this year, contains information the defendant collected during the period of the conspiracy, including 2004 and earlier. But there is more. As noted, the book contains contact information for, and then we don't know what they say. In any event, this exhibit is relevant, even if it was created after the period of the conspiracy. So they're saying, look, listen, even if this thing wasn't put together till 2009, it's still relevant. Even though it was obviously put together before 2009. Proof that the defendant at any point in time had contact information for whoever this person is relevant to her knowledge of and participation in the crime. Take, for example, a defendant charged with a pattern of bank robberies. Where are we? If police officers searched the defendant's apartment long after the crimes were committed and discovered a list of the various bank branches the defendant had robbed, there would be no question that the list was relevant, even if it were unclear that the list was made when the list was made, right? Oh my God, my nose is just so bad. So they're saying, look, listen. If police officers are searching a defendant who is accused of bank robberies from 10 years ago, and they find a list of all the banks that the bank robber robbed, it's obviously relevant. It doesn't matter if he made the list before he robbed the banks, during the time he was robbing the banks, after the time he robbed the banks. It's a list of the banks that got robbed, and this guy is a suspect, so it's obviously relevant. Now he's going to have to answer, why do you have that list? Okay. Such a list would reflect the defendant's knowledge of relevant locations, persons, and activities involved in the alleged criminal conduct. This case is no different. No matter when the defendant had this contact information, this evidence demonstrates that the defendant knew redacted. Thus, this evidence is directly relevant to the issues before the jury at this trial. Relevant evidence need not be sufficient by itself to prove the whole fact, much less prove it beyond a reasonable doubt. It just has to tend to help add to the context for the jury. So, the government respectfully submits that this evidence should be admitted. The government seeks leave to file this letter with redactions, and then they have redactions here, filed by Damian Williams. Damian Williams, U.S. Attorney, filed by Maureen Comey, Allison Moe, Laura Pomerantz, Andrew Rohrbach, who are all assistant USA attorneys in the Southern District of New York. So that's that. Okay, well, I tried to do that in an hour. I went a little over. But yeah, so what do y'all think about that? Make sure y'all like this video, share it and all that, because I do anticipate, because I use the word trafficking, that YouTube is going to demonetize me. And if y'all have any suggestions on how I can stop being allergic to this microphone, that would be great. I see y'all are talking about the Brittany Oprah interview. That's great. Informative breakdown. So yeah, I'm gonna just spend the rest of the day kind of going over this trial. I know that there's a lot of stuff that's happened. Excuse me. I know there's a lot of stuff that happened in this trial already that I don't know about, that y'all have been teaching me and educating me on. So thank you very much for that. And do keep doing that. So I'm gonna go soon. Maybe I'll do like a Q&A, like, I don't know, like a Zoom hangout or something, so y'all can kind of tell me some of the stuff that y'all do know, what are the most important parts of this trial, because I think as it goes on, we're going to start just seeing like silly little things that aren't that important, and then like really big things that are very important, and I think the mainstream media is going to try and distract us as to like which things are important and stuff. Yeah. Do you think there'll be a verdict in the Arbery case today? Oh man, Squidward, I have not been keeping up with that case. Only thing I know about it is like the events that happened at the beginning. I do not know if there will be a verdict today. I have not been keeping up with that case. Maybe I should look into that a little bit. Yeah, interesting. Ashley Kane, you are right. Lou and Robin were living in South Florida before they moved to Nashville. It was Boca Raton. And in fact, Lou Taylor worked for a company called Prime Capital Services with Mitch Martin, who now owns and runs Stonebridge. And they both worked at the Boca Raton location of Prime Capital Services. So that's weird. It's no coincidence that Lou... This is so funny. Try putting a black nylon pantyhose over it. Okay, I'm gonna try doing that. Hopefully that helps, because I think it's because it's got like rubber or something in it. Like I have a latex allergy, and I think it's like rubber or something like latexy. I bet whoever killed Epstein is dead now. Well, my conspiracy theory is that he's not dead. Like, conspiracy. Like, I don't think he's dead. I think he's in like witness protection or something, because he just knows too much powerful stuff. Like, people who have blackmail on very powerful people, they have things called kill switch, and I have kill switches too, where if they are to turn up dead, then a bunch of information just gets released to the public about very famous people. And basically that keeps you safe, because it's like, well, if I die, daddy government, there's a kill switch, and you don't know who, you don't know how, you don't know when, where, how, but it's going to get released, and all this information is going to get released on you, right? So Jeffrey Epstein, like, I just don't think he's dead. That's just my opinion. I know it's a total conspiracy theory, but that's just one of the conspiracy theories I like actually entertain, because I don't see, like, it would have been dangerous. Like, there's no way he didn't have a kill switch. I'm a little lowly YouTuber with 16,000 subscribers, and I have kill switches. So I just don't think Ghislaine and Jeffrey didn't have those. I think he moved out of the way and is letting what's her name take the fall, and is going to live out his rich life in obscurity unless we find him. That's just what I think. It's a conspiracy, allegedly, whatever. Anyway, so I don't know. It's a conspiracy. I don't care if y'all believe me. Get off my channel. Bye. I'm so tired of the abuse that y'all put me through in these comments. I'm just not here to be controlled by you, so I'm not going to be being controlled by you. He's not dead. We'll never see him again. He's in a black site. I don't know what a black site is, but yeah, probably that. Okay. A kill switch is whenever a very powerful person will have blackmail. Let's say he has blackmail on Prince Andrew. Let's say blackmail on, I don't know, I'm trying to keep it from being political. Harvey Weinstein. Okay. Let's say he had blackmail on that guy, right? Or no, it has to be somebody in power. It has to be political. That's the problem. Let's say he has blackmail on a congressperson, right? Jeffrey Epstein, or a judge even, right? Or whatever. And there's like all these powers that be that do not want their blackmail to get out, right? Pictures of them in compromising situations with little girls, perhaps, right? Something like that. Well, he could go to that judge and say, hey, listen, judge, if something happens to me while I'm in prison, just know that I have many, many associates out here on the internet who are going to release that picture of you with that little girl on my island. So better make sure I don't die, because if I die, I have people who are going to release my stuff, and you're going to be implicated. Think about the hundreds, if not thousands of people that Jeffrey Epstein has info on. Now, think about how he could leverage that info, not just for money and power like he did, But to say, look, if I end up dead, this stuff is all gonna, I have to log into my website every day at 12 o'clock p.m. and type in my password. And if I don't, then the website goes live and it shows all these, it implicates all these, powerful people. That's called a kill switch. So if he's killed, then the information is going to come out. And I just feel like he definitely had kill switches. No information has come out. So it just makes me think he probably ain't dead. But again, that's just a conspiracy theory. That is just a conspiracy theory that I believe. Okay. Anyway, love you, mean it. I'm going to go, I don't know, take like a spiritual cleansing bath because talking about this stuff really grosses me out. Like I try to keep a good spirit so I can explain what's going on to y'all, but like I can't stay in these discussions too long because it grosses me out. So I will be staying on top of the case. I will be trying to keep together what's important and what's not as important. Wait, I compared the ear of the dead guy and Epstein. Epstein is dead. Okay, so Tammy is saying she did an ear. There's photos of him in a stretcher. Okay, I did not hear any of that. I did not see any of that. Yeah, I'm definitely going cleanse. But I will talk to y'all later. And yeah, I'll stay on top of this case. I'm probably going to have a lot more YouTube videos coming out soon. I'm kind of looking for another editor, like an additional editor, just to kind of like get stuff out faster. I want to like be having like at least 5 videos a week coming out. So if you're interested in being my YouTube editor, hit me up. Okay, talk to y'all later. Facts ain't defamation. Love you, mean it. Okay, bye.